Hello everyone. Today we'll be reporting on the rights and duties of a parent. So Article 209, pursuant to the natural right and duties of parents over the persons and property of their unemancipated children, parental authority and responsibility shall include the rearing of such children for civic consciousness and efficiency and the development of their moral, mental, and physical character and well-being. Parental authority or patria potestas is the sum total of the rights of parents over their persons and property of their children. The law requires his parents to intervene in his contractual relations, which will be discussed in Article 316 and 320, to support him, also Article 320, to correct him and punish him moderately under Article 316, Paragraph 2. The purpose of parental authority. Parental authority has for its purpose not only the sound physical development of the children, but also the cultivation of their intellectual perceptions and the nourishment of their appetitive and sensitive faculties. So the case here is Reyes v. Alvarez. Kinds of parental authority. Parental authority over the persons and over the property, which will be discussed in Article 220 to 224, Article 225, and 226 for property. Parental authority over legitimate and illegitimate children. Article 3 of PD 603. All children shall be entitled to the rights herein set forth without distinction as to legitimacy or illegitimacy, sex, social status, religion, political antecedents, and other factors. Rights must be enforced or protected to the extent that it is possible to do so. Executive Order 209, July 17 of 1987, erases any distinction between legitimate or adopted children on one hand and acknowledged illegitimate children on the other, insofar as joint parental authority is concerned. Article 210, parental authority and responsibility may not be renounced or transferred except in the cases authorized by law. Parental authority is a personal right, so it is untransmissible. There are cases when parental authority can be waived. It is the guardianship approved by the court, adoption approved by the court, emancipation by concession, and the surrender of child to an orphan asylum. In Balatbat v. Balatbat de Dairocas, when a mother has abandoned her child since infancy and eloped with another man, not her husband, as between her and the maternal grandfather who had taken care of the child, the latter should prevail in an action for the custody of the child and may be appointed guardian thereof. In this case, the court also observed that the child could no longer recognize the mother. Article 211. The father and mother shall jointly exercise parental authority over the persons of their common children. In case of disagreement, the father's decision shall prevail, unless there is a judicial order to the contrary. Children shall always observe respect and reverence towards their parents and are obliged to obey them as long as the children are under parental authority. Joint parental authority is exercised by both the father and mother respectively, unless there is a judicial order to the contrary. The father's decision prevails in case of any disagreement. So long as children fall under parental authority, they are obliged to observe respect and reverence towards their parents as well as obliged to obey them at all times. Of course, the obedience referred to parents pertains to lawful and moral orders exacted by the parents. So hindi mo siya pwedeng sabihin na pumunta ka doon at ikaw ay magnakaw. Gawin mo kasi utos ko. Diba? In Joycelyn Pablo Gualberto versus Crisanto Rafaelito Gualberto. Joycelyn and Crisanto filed for annulment of marriage. Crisanto claims that Article 211, so Article 211, yung the father's decision shall prevail, yan. And that Joycelyn is unfit in citing Article 213. Actually, this case is for custody of the unemancipated child. So the Supreme Court ruled in favor of Joycelyn as they have found the claims of Crisanto not compelling as to suffice as a ground for separating the child from his mother. So ito actually si 213. Mamaya. So in case of absence or death of either parent, the parent present shall continue exercising parental authority. The remarriage of the surviving parent shall not affect the parental authority over the children unless the court appoints another person to be the guardian of the person or property of the children. So kapag the byuda, nag-asawa, anak mo pa rin siya, ikaw pa rin ang may parental authority. Kahit na nakiasawa ka ulit sa bago at kahit na magkaroon pa kayo ng children of the new marriage. Ganon. Meron pa rin siyang parental authority over the children. So, si Article 213, which was quoted in the last case, in case of separation of the parents, parental authority shall be exercised by the parent designated by the court. The court shall take into account all relevant considerations, especially the choice of the child over 7 years of age, unless the parent chosen is unfit. So, yung sinite kanina dun sa case is itong part. No child under 7 years of age shall be separated from the mother, unless the court finds compelling reasons to order otherwise. Ayan po. No? Kaya, the Supreme Court decided to give Joycelyn the custody of the children. So, in all controversies regarding the custody of minors, the foremost consideration is the moral, physical, and social welfare of the child concerned, taking into account the resources and moral as well as social standing of the contending parents. Never has the Supreme Court deviated from this criterion. This was quoted in Gualberto, the previous case. So, in Luna versus the Intermediate Appellate Court, in custody cases, the execution of final judgment of the appellate court awarding custody to the child's biological parents may be stayed if during the hearing on execution, the child manifested that she would kill herself and escape if she would be given to the custody of her biological parents. The child's best interest can override not only procedural rules but also the parents' rights to the child's custody. When the very life and the existence of the minor child is at stake and the child is of such age as to enable her to exercise an intelligent choice, courts can do no less than respect that choice and uphold the child's right to live in an atmosphere conducing to her physical, moral, and intellectual development. So, in this case, nung ibibigay sana si minor doon sa kanyang biological parents, sabi niya, I would rather die than be with them. And since ang pinag-uusapan natin dito is the general welfare of the child, nag-give way si Supreme Court at sinabing, we respect the choices of the child kasi meron pang underlying cause kung bakit ayaw niyang sumama sa kanyang biological parents. So, yun. Article 214, in case of death, absence, or unsuitability of the parents, substitute parental authority shall be exercised by the surviving grandparent. In case several survive, the one designated by the court, taking into account the same consideration mentioned in the preceding article, shall exercise the authority. So, ayun nga. So, ito, si Article 214, no? Pagka the parents, or walang nag-survive na parents, or unsuitable yung parents, the next person that will be granted that will take parental authority over the unemancipated minor, will be a grandparent. Pag madami sila, no? I-designate ng court. So, Article 215, no descendant shall be compelled in a criminal case to testify against his parents, grandparents, except when such testimony is indispensable in a crime against the descendant or by one parent against the other. So, the descendant cannot be compelled but may do so of his own will. So, maalala nyo yung sa may RPC, yung hindi ka pwedeng piliting tumestigo laban sa parents mo. Pero pwede mo siyang gawin. Hindi ka pwedeng makompel, hindi ka pwedeng pilitin unless parent on parent action, no, or crime laban sa'yo, crime against sa'yo pala, o tapos the descendant cannot be compelled, so hindi pwedeng pilitin, pero pwede mong gawin freely by your own decision, na walang pressure. So ayan, this applies to criminal cases only. So, in People v. Artemio Invention E. Soriano, no, appellant Artemio is charged of 13 counts of rape against 16-year-old daughter Cynthia P. Invention. No. Ngayon, nagtestigo si Elven Invention, yung anak niya, no, na sinasabi niyang totoo na ni-rape ni Artemio si Cynthia. Ngayon, si Artemio, in his defense, sabi niya, hindi pwedeng tumistigo sa akin yung anak ko, citing this article 215. Sabi naman ng court, no, some court rules that like Article 215, the rule or articles refers to a privilege not to testify, which can be invoked or waived like other privileges. So, pwede, sinabi niya doon na privilege lang yung may not be compelled. No? Pero kung ginawa naman to ng bata of his own free will, so, accept nila. So, under this is also your RA 8972 or your Solo Parents Welfare Act, kung saan yung in connection nyo sa kanina pagka namatay yung isang parent or hiwalay sila, the single present parent will have parental authority. So, who is a solo parent? A woman who gives birth as a result of rape or any other crime against chastity, even without final conviction, provided that the mother keeps and raises the child. Siyempre, kung hindi mo ikikip yung bata, paano ka magiging parent? Parent left solo with the responsibility of parenthood due to the death of the spouse parent left solo with the responsibility of parenthood due to the death of the spouse. So namatay yung spouse or while the spouse is detained or is serving sentence for a criminal conviction for at least 1 year. No? So criminal conviction of at least 1 year, nagiging solo parent ka kasi nandun siya sa loob ng kulungan. Due to physical and or mental incapacity of spouse as certified by a public medical practitioner, due to legal separation or de facto separation from spouse for at least 1 year as long as he or she is entrusted with the custody of the children, due to declaration of nullity or annulment of marriage as decreed by a court or by a church as long as he or she is entrusted with the custody of the children. So yung by a church, yung pagka naghiwalay sila, yung parang sa Muslim brothers and sisters natin, ganun. Tapos, due to abandonment of spouse for at least 1 year. So kapag meron tayong meron tayong asawa, tapos biglang nawala, inabandon na ka, at least 1 year, pwede mo nang i-claim yung sarili mo as a solo parent. Bakit nga naman hindi? So, unmarried mother or father who has preferred to keep and rear her or his children instead of having others care for them or give them up to a welfare institution. So, pwedeng kasi sa bahay ampunan kapag hindi ka prepared, ganon. Ayun, you may consider yourself a solo parent. Any other person who solely provides parental care and support to a child or children. So, for example, pwedeng i-claim ni, for example, dalawa kayong magkapatid, naulila kayo ng maaga, and si kuya mo is of majority age, and then nagtatrabaho siya and he provides for you, he may claim to be a solo parent. Ito nga, kasama nga siya sa E. I'm sorry. So, any family member who assumes the responsibility of head of family as a result of the death, abandonment, disappearance, prolonged absence of the parents or solo parents. Ayun. So, who are children? Children are those, we refer to children as those living with independent upon a solo parent for support who are unmarried, unemployed, and not more than 18 years of age, or even over 18, but is incapable of self-support because of mental and or physical defect or disability. Excuse me. So, criteria for support: any solo parent whose income in the place of domicile falls below the poverty threshold as set by the National Economic Development Authority or NEDA and subject to the assessment of the DSWD. Worker in the area shall be eligible for assistance, provided, however, that any solo parent whose income is above the poverty threshold shall enjoy the benefits mentioned in Section 6, or that would be flexible work schedule, work discrimination, and parental leave of this act. So, for the supports kasi given for a solo parent, meron siyang income bracket para dun sa financial support. Pero kapag earning well naman, so above siya dun sa sa income threshold, no? Ang binibigay na lang na benefits sa ating solo parents for those who are above is yung itong section 6 or yung flexible work schedule, yung work discrimination kasi minsan hindi kinukuha yung ating solo parent kapag nalaman nilang single parent siya, and then yung parental leave, which is kaya yung mga solo parents is nag-a-apply kay DSWD ng solo parent ID for the purposes of applying for those leaves. So, ito, benefits available to solo parents: comprehensive package of social development and welfare services, or section 5 of the same article. Ito nga yung sinasabi ko kanina, no? The flexible work schedule, no work discrimination on account of status, and then yung parental leave in addition to leave privileges. So, in addition to, so for example, sa government, pag you are a government employee and meron kang, you are a solo parent, you are entitled to 3 special leaves, SPL. So, this would be your anniversary, birthday leave, mga ganun. And 5 forced leaves, which, if not used, will not be credited to your accrued leaves for monetization. And then, yung parental leave is ito siya. Additional pa siya. So, plus pa ito. And then, if ever you are a woman, meron pa kayong additional leave sa Magna Carta for Women. Magna Carta. Yan po. So, educational benefits. Yung educational benefits actually, it's not for the solo parent, it is for the children. So, and then, if ever may sakit, this comes from the funds of the DSWD. Substitute and special parental authority. So, Article 216, in default of parents or judicially appointed guardian, the filing person shall exercise substitute parental authority over their child in the order indicated. So, tulad nung sa kanina, kung sino yung by order tayo, kung sino naman ang magkakaroon ng parental authority. So, pag nawala si parents, the first one would be yung surviving grandparent, or kung marami sila, kung sino yung i-judge na ay i-declare ng court. Pag wala yung grandparents, oldest brother or sister, which is over 21 years of age, unless unfit or disqualified. Pag wala naman ito, the child's actual custodian, kung sino yung currently na naghahawak sa kanya. Whenever the appointment of a judicial guardian over the property of the child becomes necessary, the same order for preference shall be observed. Kasi meron yung mga children that are left with properties na sa kanila lang. For example, child star, yung mga ganon, yung mga nag-earn na sila ng pera nila at a very young age. So, in Macazo v. Nunez, the elder brother of a minor girl placed under the latter under the employ of a married couple. So, upon discovering that the sister subsequently indulged in adulterous and scandalous relations with her married employer, the brother asked her to return to their home, but the girl expressed preference for remaining with her employer. The brother sued for a writ of habeas corpus to obtain custody of the sister. The writ of habeas corpus will be granted despite the desire of the girl to remain with her married employer. A minor cannot choose to continue an illicit. So, ito yung parang yung kanina, yung chinus ni sinabi ni girl na magpapakamatay na lang ako kaysa sumama ako sa biological parents ko. Yun kasi pinoprotektahan natin yung interest, yung welfare ng child. Dito naman sa situation na ito, immoral na kasi yung ginagawa nila. So like the Supreme Court said, it was illicit and an immoral relationship. So the elder brother wielding substitute parental authority may thus obtain custody over the erring sister. So, ito, Article 217, in case of foundlings, abandoned, neglected, or abused children and other children similarly situated, parental authority shall be entrusted in summary judicial proceedings to the heads of children's homes, orphanages, and similar institutions, duly accredited by the proper government agency. So, there must be a summary judicial proceeding before entrustment is made. So, ayun. Article 218, the school, its administrators and teachers, or the individual entity or institution engaged in childcare shall have special parental authority and responsibility over the minor child while under their supervision, instruction, or custody. Authority and responsibility shall apply to all authorized activities, whether inside or outside of the premises of the school, entity, or institution. So, authority and responsibility shall apply to all authorized activities, whether inside or outside the premises. So, yung mga school incursions, yung for example dito sa Baguio, yung pagpunta ni St. Louis Laboratory Elementary School, LES, na mag-excursion sila dyan sa may Camp John. Ayun. Meron pa rin silang authority and parental authority and responsibility over the minor child kahit nawala na sila sa loob ng mismong school. So, St. Joseph's College versus Jason Miranda. Jason Miranda was conducting a science experiment with sulfur and iron materials. Rosalinda Tabugo, subject teacher, instructed the students not to look into the test tube until materials have cooled down. Rosalinda went out for a while. So, Jason curiously looked into the test tube and it spurted out, causing injury to him. Rosalinda and the school claimed that it was the negligence of the student to be the cause of the injury. The Supreme Court ruled that the school and Rosalinda under Article 218 of the Family Code have parental authority and responsibility over the minor child when under their supervision. So they held that the defense due to the due diligence of a good father of a family raised by the school will not exculpate it from the liability because it has been shown that it was guilty of inexcusable laxity in the supervision of its teachers and in the maintenance of what should have been a safe and secured environment for conducting dangerous experiments. So kung na-injure man siya, di ba dapat meron silang protective gear, goggles, mga ganun. So, Article 219, those given the authority and responsibility under the preceding article shall be principally and solidarily liable for damages caused by the acts or omissions of the unemancipated minor. The parents, judicial guardians, or the persons exercising substitute parental authority over said minor shall be subsidiarily liable. The respective liabilities of those referred to in the preceding paragraph shall not apply if it is provided that they exercise the proper diligence required under the particular circumstances. All other cases not covered by this and the preceding article shall be governed by the provisions of the Civil Code on quasi-delicts. Who are liable? So, principally liable are the school, administrator, teachers, or individual or entity giving childcare while under their supervision, instruction, or custody. So, while under their supervision, instruction, or custody. Subsidiarily liable are the parents, judicial guardians, or the persons exercising substitute parental authority. The liability shall not apply if proper diligence required under the circumstance is given. Other cases not covered are referred to the provisions on the Civil Code on quasi-delicts. So, effects of parental authority. Article 220. The parents and those exercising parental authority shall have, with respect to their unemancipated children or wards the following rights and duties: to keep them in their company, to support, educate, and instruct them by right, precept, and good example, and to provide for their upbringing in keeping with their means; to give them love and affection, advice and counsel, companionship and understanding; to provide them with moral and spiritual guidance, inculcate in them honesty, integrity, self-discipline, self-reliance, industry, and thrift, stimulate their interest in civic affairs, and inspire in them compliance with the duties of citizenship; to enhance, protect, preserve, and maintain their physical and mental health at all times; to furnish them with good and wholesome educational materials, supervise their activities, yung recreation and association with others, protect them from bad company, and prevent them from acquiring habits detrimental to their health, studies, and morals; to represent them in all matters affecting their interests, to demand from them respect and obedience, as earlier mentioned, to impose discipline on them as may be required under circumstances, and to perform such other duties as are imposed by law upon parents and guardians. Napakahaba nga, no? So, some duties: to support even after reaching the age of majority; to have children in their company. For this purpose, the writ of habeas corpus may be availed of if the children are in the company of others who refuse to surrender them, and this is so even when the children voluntarily desire to be with said others. Yan. To educate them and instruct them within their means; to represent them in all actions which may redound to their benefit. So, yung kanina, yung kontrata, yung mga ganon. To correct and punish them moderately. Moderately po, no? Kasi pag lahat ng sobra, masama. Branson V. Alvear. So, the father entrusted his child to the custody of a relative, and then the father left for abroad. Meantime, the mother claims custody, but the relatives refuse on the ground that the child had been left to them by the father. The mother can get the child, for in default of the father, the mother can assume custody and authority over the minor. Article 221. Parents and other persons exercising parental authority shall be civilly liable for the injuries and damages caused by the acts or omissions of their unemancipated children living in their company and under their parental authority, subject to the appropriate defenses provided by law. The basis of parental liability for the torts of a minor child is the relationship existing between the parents and the minor child living with them, and over whom the law presumes the parents exercise supervision and control. So, yung mga nagsha-shoplift na bata, ganun, ang actually na may liability is yung parents, kasi first and foremost dapat natuturuan nila yung natuturuan nila ng tama yung bata as per the other so yung morals and no minor child. So kapag nakagawa sila ng ganong klaseng action, the parents are liable. So what is a tort? A tort is a civil wrong, so civil siya, that causes a claimant to suffer loss or harm resulting in legal liability for the person who commits the tortious act. Tort law can be contrasted with criminal law, which deals with criminal wrongs that are punishable by the state. Tamargo v. Court of Appeals. The civil liability imposed upon parents for the torts of their minor children living with them may be seen to be based upon the parental authority vested by the civil code. So ito ngayon, yung dahil nga meron kang authority and responsibility over the minor, yung liability falls upon you also. So the civil law assumes that when an unemancipated child living with its parents commit a tortious act, the parents were negligent in the performance of their legal and natural duty closely to supervise the child who is in their custody and control. The shooting of Jennifer by Adalberto with an air rifle occurred when parental authority was still lodged in Bundok spouses, the natural parents of the minor Adalberto. It would thus follow that the natural parents who had then actual custody of the minor are the indispensable parties to the suit for damages. So, the parents. Article 222. The courts may appoint a guardian of the child's property or guardian ad litem when the best interests of the child so requires. Whenever the best interests of the child are at stake, courts may appoint a guardian of the child's property or guardian ad litem. Guardian ad litem is an advocate for a child whose welfare is a matter of concern for the court. The parents, or in their absence or incapacity, the individual, entity, or institution exercising parental authority may petition the proper court of the place where the child resides for an order providing for disciplinary measures of the child. The child shall be entitled to the assistance of counsel, either of his choice or appointed by the court, and a summary hearing shall be conducted wherein the petitioner and child shall be heard. However, if the same proceeding the court finds the petitioner at fault, irrespective of the merits of the petition, or when the circumstances so warrant, the court may also order the deprivation or suspension of parental authority or adopt such other measures as it may seem just and proper. No? So Article 223 is when it is when the parent, the person who has parental authority over the minor child would go to court and ask the court for more, ano ba, what's the term? A more a harsher punishment for the child. Um, Kasi 'di ba, the previous article is to discipline them moderately. Dito naman is to ask ito. Uh, for an order providing for disciplinary measures over the child. So, for example, kasi hindi na nga makontrol ni parent. Hindi na makontrol ni parent si minor child is punta ako sa court, judge ganito, baka naman pwedeng turuan nyo ng ano, doon muna siya sa DSWD, mga ganon. Ito. So, Article 224, the measures referred to in the preceding article may include the commitment of the child for not more than 30 days. So, yung kanina nga, pag kinumit nila doon sa, doon sa institution na yon, so not more than 30 days, in entities or institutions engaged in childcare or in children's homes duly accredited by the proper government agency. So, in connection with 223, pag i-commit na nga nila is not more than 30 days. Not more than 30 days. The parent exercising parental authority shall not interfere with the care of the child whenever committed, but shall provide for his support. Upon proper petition or at its own instance, the court may terminate the commitment of the child whenever just and proper. So, kahit na yung yung bata is na-commit mo doon sa institution na yon, magpro-provide ka pa rin ng kung ano mang support, financial man, food, pero will not interfere with the care of the child. So, the parent exercising parental authority shall provide for his support but shall not interfere with the care of the child whenever committed. So, Article 225, the father and mother shall jointly exercise legal guardianship over the property of their unemancipated common child without the necessity of a court appointment in case of disagreement. The father's decision shall prevail unless there is a judicial order to the contrary. So, that's twice already, no? If there is disagreement within for the decisions regarding the unemancipated minor, the father's decision shall prevail unless there is judicial order to the contrary. Where the market value of the property or the annual income, ito na pala, so over the over the property. Yung 220 to 224 kanina, that's over the person of the child. Where the market value of the property or the annual income of the child exceeds 50,000, the parent concerned shall be required to furnish a bond in such amount as the court may determine, but at less than 10% of the value of the property or annual income to guarantee the performance of the obligations prescribed for general guardians. A verified petition for approval of the bond shall be filed in the proper court of the place where the child resides, or if the child resides in a foreign country, in the proper court of the place where the property or any part thereof is situated. So, yung loss on real property. The petition shall be docketed as a summary special proceeding in which all incidents and issues regarding the performance of the obligations referred to in the second paragraph of this article shall be heard and resolved. All such incidents and issues shall be decided in an expeditious and inexpensive manner. So, expeditious and inexpensive manner without regard to technical rules. The ordinary rules on guardianship shall be merely suppletory, except when the child is under substitute parental authority or the guardian is a stranger or a parent has remarried, in which case the ordinary rules on guardianship shall apply. So, regardless of the value of the properties of the child, the father and mother ipso jure become the legal guardian of the child's property. Ito lang, if the market value or annual income of the child should exceed 50,000, kailangan mo ng bond. As in the SEC, when we say a bond, it is a surety bond that is taken with a bank with regards to the what do you call this? With regards to a certain amount, for example, the capital of a one-person corporation whose sole director is also the treasurer. So, 10% of the aggregate property. So, let's say 50,000. So, kailangan meron kang 5,000 na bond. For 1 million, you need at least 100,000 na bond. Para pagka may nangyari dun sa pera, covered siya, para siyang insurance. If both parents are the guardian of the property and there is no conflict of decision, then the father's decision shall prevail. If the father is absent or incapacitated, it is the mother who shall be the legal guardian of the properties. So, Luz Pineda et al. V. Court of Appeals. Regardless of the value, yan nga. Ito siya. The second para is of the market value of the property or the annual income of the child, which means that the aggregate of the child's property or annual income exceeds 50,000, then a bond is required, which is 10% of the aggregate. So kung marami-rami siyang pinagkukuhanan ng pera, may annual income, meron siyang apartment, meron siyang real estate. So yung total amount niya or yung market value niya na sabihin natin 500,000 na 100,000 na income, and then 500,000 na lupa. So 600,000. Yung 10% nun must be bonded. Article 226. The property of the unemancipated child, earned or acquired with this work or by onerous or gratuitous title, shall belong to the child in ownership and shall be devoted exclusively to the latter's support and education, unless a title or transfer provides otherwise. The rights of the parents over the fruits and incomes of the child property shall be limited primarily to the child's support and secondarily to the collective daily needs of the family. So, for example, si Child Star, nagpatayo siya ng apartment, yung income na na-generate ng apartment or yung income niya doon sa sa kanyang pag-child star, actress. Sabi dito, should be limited primarily to the child support. So, kukuha lang sila doon kasi hindi naman talaga nila siya pera ng bata para sa pang-aral, pambili ng mga gamit ng bata. And secondarily lang yung collective daily needs of the family. So, syempre kung bibili ng food para doon sa bata, kung pwede na rin lang naman na isabay yung para sa kanyang mga kapatid, sa kanyang parents, edi isasabay na sana. So for example, it is the term used in here in the Luzon. Ilak-amam ni Manang, ilak-am to include no gumatang tayo tea stuff. Yeah. So, fruits of the property is for the support and educational child unless provided otherwise by title or transfer. Meron kasi yung pag ito sa gratuitous title, for example, meron akong mayaman na uncle, sabi niya itong i-donate ko sa iyo or sa iyo na lang ito, tapos kung ano man yung dyan, ibabangko mo lang para may pang-aral ka in the future. So hindi yun pwedeng galawin. So property of the acquired by the child with his work or industry by onerous or gratuitous title. Article 28. Parental authority terminates permanently upon death of the parents, upon death of the child, or upon emancipation of the child. So, the patria potestas or parental authority here is terminated permanently. So, syempre, pag namatay yung parents, yung parental authority nila over the child is what gets terminated. Pero nakikreate yung panibagong parental authority doon sa mag-hold ng custody over the child. And of course, upon death of the child, pag namatay yung child, wala nang parental authority over him because and upon emancipation, so upon emancipation of the child, ang clear na emancipation natin is reaching the age of majority. Since RA there is a law that made the age of majority from 21 to 18. So, unless subsequently revived by final judgment, parental authority also terminates upon adoption of the child. So, ito sa upon adoption of the child na to terminate yung parental authority nung may custody ng child. So, for example, may custody ako dito sa minor, pinaampon ko yung minor, ang nata-terminate na parental authority is yung relationship namin dalawa, hindi yung doon sa mag-adopt sa kanya. So, ganun din dito yung upon appointment of a general guardian, ganun kasi kunyari abusive ka na parent, let's just say, for example, abusive ka na parent, and then sabi ng court, doon ka muna kay tita mo, siya yung ginawang guardian, nata-terminate yung sa ating dalawa kasi iba yung may hawak sa'yo ngayon. So, upon judicial declaration of abandonment of the child in case filed for the purpose. Upon final judgment of a competent court, divesting the party concerned of parental authority. So, yun nga, yung kanina, yung sinasabi ni court na wala ka ng parental authority over the child because of certain circumstances. Upon judicial declaration of absence or incapacity of the person exercising parental authority. Pagka biglang nasiraan ng bait perfect example si Sisa, 'di ba? Nabaliw siya. So, ayun, incapacity. Or absence of the person, yung inabandon ka na lang, nag-ghost ka ni mommy or ni daddy. Ganon. The terminated parental authority may be subsequently revived by final judgment. For example, parental authority exercised by the orphanage is terminated upon adoption. Pero, dun sa nag-a-adopt, yung adopter, nagkakaroon siya ng bago. Tapos, for example, bumalik ka ulit dun sa same na orphanage na yon, yung terminated na parental authority nyo, mare-revive siya dun sa pag naibalik ka doon sa orphanage. The court appoints a general guardian for minor who is allegedly abused by the parent. Example ko kanina. And when a parent has proved to have abandoned the child, the parental authority the former had for the latter is terminated. So, in essence, parang natatransfer siya, pero ang totoo is nataterminate yung parental authority pag nag-change ng custodian yung bata. So, in Pasita Chua v. Kabangbang. So, ito, si Pasita Chua is ito, and his wife, ito, nagkaroon siya ng anak sa isang lalaki na hindi niya pinakasalan, tapos yung batang yun is pinamigay niya sa mga kabangbang, no? So sila, pinalaki naman nila yung bata. So ito, on June 6, 1963, Pasita Chua demanded the surrender to her of the child. Failing to secure such custody, she filed for a petition of habeas corpus. The lower court dismissed the petition and concluded that it would be for the welfare of the child to stay with the kabangbangs. So, nag-appeal siya. Nung nasa Supreme Court na, Supreme Court held that the mere acquiescence of Pasita Chua to Villarreal's giving of the child to the kabangbangs without more is not sufficient to constitute abandonment. But the records yield a host of circumstances which in their totality show the intention of Pasita Chua to forgo responsibilities and forever relinquish all parental claim in respect to the child. Kasi sa course during the duration of this, bago siya mag-file, is ang dami niyang chances para ipakita na gusto niya i-reclaim yung custody ng bata, pero hindi niya ginawa. Kaya the Supreme Court held, sabi niya nga dito, no, na kahit na hindi sufficient na to constitute abandonment yung pag sabi niya, sige, ibigay mo kay Kabangbang yung bata, pero yung ibang acts niya kasi leading up to the filing ng itong pag-file niya ng habeas corpus to reclaim the child is hindi nakitaan ng Supreme Court na gusto niya nga na actually makuha yung bata. So, Article 230, parental authority is suspended upon conviction of the parent or the person exercising the same of a crime which carries with it the penalty of civil interdiction. The authority is automatically reinstated upon the service of the penalty or upon pardon or amnesty of the offender. So, maalala nyo earlier, no? So, doon sa solo parent welfare act. Sabi niya, you can become a solo parent if your partner or your spouse mo is sentenced to more than 1 year imprisonment, kasi hindi siya magiging available para doon sa bata. You are considered single parent. So ganun din dito, na extinguish yung parental authority niya, no, because of the civil interdiction. Pero this is not a termination, it is only a suspension of parental authority. So upon service, pagka na-render mo na yung punishment, or upon you getting out, and the suspension is lifted for parental authority. The court in an action filed for the purpose or in a related case may also suspend parental authority if the parent or the person exercising the same treats the child with excessive harshness or cruelty. So pwede nilang isuspend. Gives the child corrupting orders, yung magnakaw ka. Ito, compels the child to blame. Subject the child or allows him to be subjected to acts of lasciviousness. The grounds enumerated are deemed to include cases which have resulted from culpable negligence of the parent or the person exercising parental authority. The degree of seriousness so warrants, or the welfare of the child so demands, the court shall deprive the guilty party of parental authority or adopt such other measures as may be proper under the circumstances. The suspension or deprivation may be revoked and the parental authority revived in a case filed for the purpose or in the same proceeding if the court finds that the cause therefore has ceased and will not be repeated. So, pwedeng ibalik kapag ayun nga, kita nilang hindi na siya, nagbago ka na, you're not beating your child, yung mga ganun. So if the person exercising parental authority has subjected the child or allowed him to be subjected to sexual abuse, such person shall be permanently deprived by the court of such authority. Ito yung pinasok mo siya sa child prostitution, binenta mo siya, ganun, permanently deprived. The person exercising substitute parental authority shall have the same authority over the person of the child as the parents. In no case shall the school administrator, teacher, or individual engaged in child care exercising special parental authority inflict corporal punishment upon the child. So, corporal punishment is a punishment which is intended to cause physical harm. So, actus non facitrium nisi minsit rea, or an act does not render a man guilty of a crime unless his mind is equally guilty. So, kung ang intention mo lang is, ano naman actually, to discipline the child. Kaya nga, yung term na moderate. Yung term natin na moderate. Yan. Marcela Bagajo. So, in Bagajo v. Marave, Marcela Bagajo, the teacher of Wilma Alcantara, stepped out of the classroom to go to the principal's office. During the period in which she was out, Wilma Alcantara tripped Benedicta Gurigay. Benedicta hit her head on the edge of a desk, and an umbrella poked her stomach and a nail the desk to her knee, causing her to faint. Marcel returned to the classroom and asked Wilma about the incident, to which the latter denied anything to do with the incident. Marcela became angry, and with a piece of bamboo stick, which she uses to teach the class as a pointer, hit Wilma behind her legs and thighs, causing bruises to her. Marcela was acquitted from her criminal liability by the Supreme Court without being prejudiced to her civil liability, which is inflicting corporal punishment. So yung physical injuries na which she was acquitted with that. Pero yung corporal punishment, hindi naman talaga niya ito nga si Actus hindi naman talaga niyang gustong i-cause yung physical injuries. Ito sa form of punishment, pero dahil nga bawal ang corporal punishment, hindi siya absuelto sa kanyang civil liability. Article 234, emancipation takes place by the attainment of majority age unless otherwise provided. Majority commences at the age of 18 years under RA 6809 or the act lowering the age of majority. So yun yung kanina, no, yung doon sa when does what extinguishes parental authority is upon the reaching the age of majority, because that would emancipate you. So the provisions governing emancipation by recorded agreement shall also apply to an orphaned minor and the person exercising parental authority, but the agreement must be approved by the court before it is recorded. This is expressly repealed by RA 6809 or the act lowering the age of majority. Ito naman tayo sa RA 7610. So an act providing for stronger deterrence and special protection against child abuse, exploitation, and discrimination, and for other purposes. So section 5 to 10 of this RA is yung mga acts against the child. So yung child prostitution and other abuse, attempt to commit child prostitution, child trafficking, attempt to commit child, so attempt, obscene publications and indecent shows, other acts of neglect, abuse, cruelty, and or exploitation, and other conditions prejudicial to the child's development. So kaya ko actually natanong before kay judge yung tungkol doon sa sa grooming, kasi baka I think it falls under here, kasi yung pag-train mo sa kanya is an act of exploitation, kasi hindi mo naman siya matitrain kapag hindi ka naman niya trust, no? So na-exploit mo yung trust sa this is my own opinion, pero na-exploit kasi nung person yung yung trust mo sa kanya, ikaw minor, kuya mo siya or na you trusted him, so dahil alam niyang trust mo siya, ito ang gawin mo. So there, in violation of section 5 to 10 of RA 7610, so the violation of it is also in violation of article 209 if you violate this one of the family code. Yung parental authority and responsibility shall include the caring for and rearing of such children for civic consciousness and efficiency and the development of their moral, mental, and physical character and well-being. It is also in violation of article 220, sections 1, 2, 3, 4, and 5. Violation of RA 7610 through sections 5 to 10. So pag ginawa mo ito, yan, no? Also suspends parental authority via article 231. So who may file a complaint? So syempre yung bata, offended party, yung parents or guardians ng bata pag iba may gumawa, ascendant or collateral relative within the third degree of consanguinity. So pwedeng si lolo, si auntie, ayan. Yung officer, social worker mismo nung child caring institution pag nalaman niya, yung social worker ng DSWD pwede, yung barangay chairman pagka nalaman niya, or yung mga kapitbahay niya, yung mga marites natin na very concerned. Yan. So yung protective custody of child, the offended party shall be immediately placed under protective custody of the Department of Social Welfare and Development pursuant to Executive Order number 56 series of 1986, or authorizing the Ministry of Social Services and Development to take protective custody of the child, prostitutes, and sexually exploited children for other purposes. In the regular performance of this function, the officer of the DSWD shall be free from any administrative, civil, or criminal liability. Custody proceedings shall be in accordance with the provisions of Presidential Decree. So itong part na ito, no, kasi malala nyo kung sino yung may parental authority, siya would be responsible over the acts of the child. Yung tortious acts niya. So dito sabi ni meron siyang disclaimer. So they will be free from civil, administrative, or criminal liability kung sakaling man may makomit yung bata during their care. So yung common penal provision is the penalty provided herein shall be imposed. So si RA ito RA natin na ito meron siyang penal provisions, pero all the penal provisions will be imposed in its maximum period when the perpetrator is an ascendant, parent, guardian, step parent, or collateral relative within the second degree of consanguinity. Wala ang aking pointer or affinity. Which has no license to operate or its license has expired or has been revoked. Ito, yung sa may institutions naman ito. And that would end my presentation. And there you go. Thank you. Bye.